This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael.
Today, we're chatting with Dado Hrustanpasic. Dado is a partner at Holding Redlich and lectures on construction dispute resolution at the University of Melbourne. Dado is dual qualified in law and civil engineering with nearly 15 years experience in major project disputes and is a leading voice in construction and infrastructure in Australia. In this episode, Dado will explore the evolution of major project delivery in Australia. He'll explain the common triggers of dispute on projects, when to use certain resolution strategies, what steps can be taken during the contract drafting and project launch stage to try and prevent disputes before they even happen. Let's jump in. Dado, welcome to the show.
Thank you.
Let's set the scene here. Over the past 10 years, what types of infrastructure projects have generated the most significant disputes?
The way to think about it, I think, is we have had a number of waves of infrastructure projects over the last 10 or 15 years. And there have been some trends in the types of disputes that have risen out of those infrastructure projects. One can think about, in particular, the large delivery of a number of very significant LNG projects about 10 years ago led to a very significant disputes on almost all of those projects and were resolved in a number of ways, but many of them were stuck in very significant disputes. We have had also mining boom before that, led to some significant disputes, but probably not as consistently as with the LNG projects that were occurring around early last decade. After that, we've had infrastructure pipeline has focused much more on road and rail in urban areas. And it's been interesting to observe that the kinds of disputes have risen and any complex project, almost any complex project with perhaps some notable exceptions, ends up having some sorts of disputes. But how those disputes have arisen and been resolved has been markedly different to what we saw in the resources and oil and gas sector before it. And equally then we have now and in the future, a large infrastructure spend associated with renewable energy and the energy transition. And again, we are seeing different types of disputes coming out of those projects. And it's interesting to compare and contrast those and maybe think about what kind of lessons that might mean for future infrastructure spending and waves of infrastructure construction.
That sounds very interesting. So before we get into the future, let's dive a bit more into why do we think that is the case for the LNG projects, let's say. So compared to the mining projects, you mentioned LNG projects have had slightly different nature of disputes. Why do you think that is the case?
There's a number of reasons. We'll go through them in no particular order. One is that there was, at the time of those projects starting, there was often a sense of urgency for major projects to be delivered, but in particular, the economics of those projects meant there was a focus on getting to the market and getting gas into ships and getting it off into Japan and other international markets. And that led to so-called fast-track delivery, which caused stress when it comes to design and dealing with unexpected issues during delivery of the project. That's one factor that led to stress in a lot of those projects. Another factor was probably the nature of the participants. The owners of a lot of those projects were delivering projects that they had not delivered before. They were bringing in contractors from Australia who had not participated in the Australian market before. And that led to stress points where participants were dealing with complex projects that either they hadn't delivered in this market or hadn't really delivered at all before. Then it's the nature of the contracts was really most of those contracts were effectively EPC or lump sum contracts where there was a large risk transfer or purportedly a large risk transfer to the contractor. And that led to quite positional disputes or positional bargaining when it came to resolving the disputes. So I think those are significant factors looking back on a range of very significant disputes that came out of the LNG sector. And probably a fourth one, if we contrast it to some of the mining projects, is that there was a lack of repeat business, if you will. So the contractors that were doing these projects weren't going to deliver another one. There was no real need to sustain a good relationship between the owner and the participants. And that, again, influenced how people dealt with disputes when they came up.
It's interesting when you mention everybody is really just looking after their interests. I've never heard once, let's look after the project's best interests. It is unfortunate that in that way. Now, what we've discussed so far is we've got the private money that is flowing in these projects, particularly for the LNG and the mining projects, whereas compare that to the government projects in the linear infrastructure, which is road and rail, tunnel. That's mostly government money, and they do have some sort of design at the start before they go into tendering. But, you've mentioned there has been similar types of disputes, if not due to the same structure or at least at the same level. Perhaps not in the millions or billions as the LNG projects, such as ICTIS, IMPEX, and some other major ones. But let's say projects like Metro Tunnel, Westgate Tunnel, they've all had very, very significant amount of disputes. Why do you think that is the case, despite being two separate types of owners and they're moving slightly differently in the project development phase?
It is a reflection that complex projects, no matter the sector, no matter the objectives, no matter the commercial structures and players, are difficult to deliver and prone to becoming, and I use the term stressed, to be sort of neutral about who's responsible for the fact that a problem arises. And it is hard to experience shows. It is hard for everything to go smoothly on those projects, given the complexities that are involved in delivering them. So what I think that tells us is that while there might be some merit in being optimistic about the next project, one shouldn't have optimism bias about delivering projects. And the history tells us that on projects where they're new, there's not a long history of delivering that type of project, or there's unexpected issues that need to be dealt with, that will result in stress. And so we should think about how do we plan for that and how do we try to resolve that in a way that is, and you mentioned the term best for project, maybe best for project, but at least perhaps best for all the participants involved to deliver the project consistently as they can with their objectives, which will vary between the participants. But thinking about what will happen when those stress points come on projects, I think is a much better approach than just, hoping it doesn't and then dealing when it does.
That's really interesting. Which brings me to my other point of discussion about contract models. Now, adversarial contract models are the norm, as they seem to be in major projects such as in the LNG sector and the mining sector, typically, which is also directed by the fact that there's not always repeat business. It's a significantly large project that might not happen again. And how does the commercial context influence the negotiation behavior when disputes actually arise?
It's an interesting question. I think effectively comes down to where the risk sits and how is risk shared, if it's shared, when a problem is encountered. An EPC model, or a more elaborate way of saying something that is essentially a lump sum kind of delivery model, purports to transfer the risk of most events onto the contractor with limited entitlement to change the contract price. And if something happens, the contractor is dealing with it at their own risk. Now, what that leads to is contractors adding high-risk premiums to their price and attempting to predict what they will need in terms of contingency to cover unexpected risks. But we all know that that is an incredibly difficult thing to get right, if at all possible. And there have been interesting studies that show that the way in which most contractors approach that probably does not truly reflect the level of risk that they are taking on for projects that go significantly badly. So a contractor might say, well, 30% of projects end up sort of being this much over, and maybe I can take some count of that. But the sort of projects, maybe it's not that many, but a certain number of projects go very, very badly, and risk premiums can never cover that eventuality. Or if they did, the price would be so high that nobody would do it. So what that means in terms of a dispute is that if you enter into that territory where a project's going very, very badly, a contractor will have an incentive to fashion something to try to deal with the situation which it's in, which is essentially going into claims and doing whatever it can to pressure the principal and recover further money that perhaps it wasn't anticipating in the original contract price. If you have a contract model where there is a sharing of risk, and we're seeing a lot more of that in infrastructure delivery these days, it shifts the incentives when significant events happen that cause significant stress to the project. So if the contractor's risk is capped, for example, at a particular point, and we're seeing projects delivered under those models, there is still a problem that needs to be solved, but the contractor is entering that knowing that their entire business is not at risk. They may be sharing some of those costs. The principal is also sharing some of those costs. It creates an incentive to resolve a dispute in a way that minimizes the cost for both parties, or at least tries to achieve an outcome that means both parties can move forward. So I think when front-end practitioners and people who are setting up the contract models think about risk transfer, but the nature of the contract model also will influence what incentives parties have when it comes to a dispute and working together to resolve a dispute and move forward on a project.
When projects are being delivered under these fixed price contracts, let's say lump sum fixed price contracts, does it always have to be that it's one or the other? I mean, Australia has one of the highest adoption rate for amended contract forms. Yes, there are some contract forms that exist, but it has been demonstrated in research by the University of Melbourne Law School that more than 80% of contracts are amended to some extent. Then why don't we use that as an opportunity?
It's not higher.
It's higher. Okay. So, okay. Why don't we use that as an opportunity instead and perhaps make a bespoke contract out of a fixed price contract? What do you think about the opportunity where you investigate what are the things in the project that are very, very hard to understand and negotiate on that? And then you go to the middle ground. Okay, we don't know quite where we will land with these. Maybe we'll take these as provisional sums. And then you go on the other aspects where we definitely know that this is the most amount of money we are going to pay for it, and just lock it in and have separate dispute resolution mechanisms for the separate parts of the contract. Now, I know this adds more work for the administration, but if you're going to amend the contract, why don't you go all the way? What do you think as a disputes lawyer in that type of context?
I think it's a fabulous idea. I mean, it's not necessarily common, but we do see contracts where you have separate payment models and separate risk transfers for separate issues. So you could say, well, as you say, we'll lump sum this aspect might be a cost sharing reimbursable, and this aspect, well, we take no risk because we just don't know what's going to happen, and that might be the structure of the contract. As to whether you should have different dispute resolution mechanisms for different elements, I don't think I've heard that suggested before. It's a really interesting idea. What comes to me, though, is what that tells us is parties who want to avoid or have an incentive to resolve a dispute and move forward with delivery should approach dispute resolution with flexibility. The idea, I think, that a front-end lawyer can design a dispute resolution mechanism that is perfect for any eventuality, I think is unlikely. And I think as dispute resolution lawyers, we should be open to working together, maybe not to obviously each side will have its incentives and have the positions and arguments it wants to make, but we can work together on a mechanism when a dispute arises about the best way to design a process that will be right for that dispute to get us to a point where we can have a solution, resolve the dispute, and move forward with delivery in the least disruptive way. So there are probably things that can be done, things are done in contracts to set that up, but I think parties and practitioners should be flexible to changing those if it makes sense for the particular circumstances that they find themselves in.
I agree as well. But it's interesting to think that parties probably wouldn't consider that approach. And there's always this interest of keeping yourself safe and the interest of your organization safe. And that probably comes from a place of, as humans, we want to do good in the job that we do. And then that translates sometimes unintentionally into protecting the interests of the employer as risk allocation to a point where it's unlikely to be able to be managed at all. It's all very interesting. Now, for the last 10 years, we're in the discussion of dispute resolution now. What I am aware of, the extreme type of dispute management process is the litigation, which is extremely formal. And then we go on to less formal, but maybe suitable for other contexts such as arbitration, expert determination, mediation, and dispute boards. Now, in your experience in the last 10 years, what have you seen in the industry for the projects that we've been talking about in the resources sector and the mining sector?
I think it used to be that arbitration was the way to go for almost all significant resources and large infrastructure disputes. That's probably changed a little bit, recognizing the challenges, not necessarily impossibility, but the challenges to arbitration when there are multi-party disputes. And multi-party disputes are becoming much more the rule rather than the exception for complex dispute resolution. The proportionate liability regimes in all of the Australian states influence that significantly, and the general improvement in the processes of state Supreme Courts and the federal court has changed how parties perceive the relative advantages of arbitration and litigation. You mentioned dispute resolution boards and other forms, alternative forms of dispute resolution. That is certainly becoming more prevalent. And if we think about trends, I'm not sure we have names for them yet, but there are new forms of dispute resolution being developed more in that bespoke, circumstantial area that I was discussing than a sort of a particular category that we have a name for. But there are examples in major projects of what might be termed prolonged structured facilitated negotiation, where somebody is appointed to lead a dispute resolution process where that plays out over a fairly lengthy period, where there is engagement at different levels of the organisation at different points in time to try to, what any facilitated negotiation tries to do, which is to get the parties to see each other's points of view, narrow what they're in dispute over, and find compromises that they may not yet have perceived. But given the complexity of the projects that we're talking about, that can take many weeks or months, and it might take input from not just lawyers, but engineers, technical people, commercial people, senior executives at the right points in time to drive a dispute toward getting narrower and getting to something that's solutions focused rather than out positional. And as I said, that takes time. It's hard to design before a dispute comes up, but it's an interesting trend in complex dispute resolution. I think one that should be followed in the future in the appropriate circumstances. So I think that is the future when it comes to parties recognizing that on a complex project, particularly where they have ongoing relationships or there will be relationships in the future, a stressed project is everyone's problem and a solution needs to be found. And the best way to do it is through the parties finding it themselves with multidisciplinary advice and assisted by somebody who is there to help them solve it rather than there as an ultimate decision maker in the form of a arbitration or litigation. And it's a little more developed than, say, a mediation or a dispute resolution board because it's someone actively guiding the parties through a facilitated process.
This sounds very much like a process where there is no set process, if you'll entertain me. It's a very much of a combination of anything you like and you need for the task at hand, which is really great because whether you need an expert to determine this matter so that you can move to the next step without having to go through this whole expert determination process and that to be final, and then again to argue that, oh, it's not final, I didn't like that. And then you've got the mediator who, again, has to abide by a set of rules which are well-structured, designed in a particular manner that should be fair. Well, I think in all of dispute resolution process, fairness is probably the key driver that drives the whole thing. And if any party feels at any point in time that the fairness is not there, then you're in a bit of a problem. So for this type of dispute resolution mechanism that you've just mentioned, I think there needs to be a significant incentive for both parties to continue a long-term working relationship. So from my perspective, the resource sector and the mining sector, it's unlikely they will ever adopt it, but they might. You never know, particularly with the renewable energy transition, with very limited players in the market that can actually deliver those sorts of projects at that scale, and the integrated nature of you needing not just generation, you need distribution, transmission, generation, you've got retail. The whole energy sector needs to be integrated into those companies' businesses. And I think they might adopt it, but they might not. But what I'm feeling at the moment is it's probably the continuous projects like, let's say, Sydney Metro that has been going on for 15 years now almost. And then level crossing removal projects, they are all operating on some sort of collaborative scheme. And that might be what is driving that behavior. What do you think?
Those are very good observations. I think where there are limited players who can deliver these projects, and in those circumstances, there is much more of an incentive to realize that a stress project is a shared problem because it needs to be delivered and the next one will need to be delivered, and the problem is one that has to be solved mutually. Now, that's not to say everyone just kind of throws the contract away and just goes and isn't realistic about it, but it's a recognition that there are broader factors than just what legal position can you take under the contract. And we've seen that play out in infrastructure where the broader market requirements, the nature of the participants has influenced what happens when it comes time to come to a mutually acceptable position. So it's not something I'm advocating for run-of-the-mill construction project. It's really something that on large infrastructure where there is, as you say, a long program, there might be multiple packages, there is a need to deal with problems as they come up, find ways to solve them and then continue with the project, that those circumstances are driving parties to think about how can we do this differently and in a way that is suited to the needs of our needs and the needs of the project, and to delivering essentially what the country and the society needs in a broader sense than just the immediate commercial interests of the parties involved. And I should say, as we've mentioned, the complexities of multi-party disputes is that you can, again, deal with bringing in all of the people who need to be there to come up with a solution that works for everyone involved, not just, say, the two parties at the head of the table.
Thank you. I'd like to touch a bit more on the multi-party dispute concept that we're talking about here. Typically, in the major resources projects, there's one EPC contract. You've got the owner with the money, the contractor with the skills, and they get together and they fight together as well, or against each other, for a better word, when they get to disputes. with the introduction of proportionate liability, if things do get litigated, then it can get quite stretched and lots of parties can get involved, even if they don't have a contractual relationship directly with the principal, let's say. Is that correct? Have I understood that correctly, firstly? Is there a potential for that to happen in the big projects as well?
Yeah, depending on the nature of the claim, certainly the proportionate liability scheme means that if, without getting into a lecture about exactly how that works.
Well, I've been on one with you already.
So you want to avoid it at all costs. If there is a claim essentially arising out of a failure of reasonable care, the liability for the damages can be apportioned to across a number of parties, and in a litigation context, usually what will happen is that those parties will be joined to those proceedings so that the liability can be apportioned across the parties that might be responsible for the loss or damage. The High Court has told us that in an arbitration, the proportionate liability, and again, somewhat simplistic, but broadly, proportionate liability will apply. And even if a party is not present in the arbitration, they can have liability apportioned to them so that the claimant cannot recover the whole of their loss against whichever party is in the arbitration. So that's a long answer, which I feared, to a simple question, which is yes, the nature of the legislation now is that it is any disputes that involve broadly a lack of reasonable care, which is many, tend to quickly become multi-party because there is a need to apportion liability. Now, that's not the only issue. I mean, even without apportionment of liability, you can have the need for multi-party disputes even in a supply chain setting. So a principal might say, well, contractor, this material is defective. Contractor says, well, I deny that, but if it is, then my subcontractor or supplier is at fault for that. And then someone might say, well, no, it wasn't the material that's defective, is the design that was defective, or the installation was defective. And so people are pointing fingers at each other. And the typical way that is tending to be resolved is that it's best to have everyone there so that can be sorted out and you don't have three different disputes running where you might get all sorts of different decisions that don't make sense with each other. So as over the years, multi-party disputes have become more common, that sort of feeds becoming even more common because people deal with it more and more. And so, as I said, it is now almost the exception to have simple two-party bilateral disputes where you don't have to worry about everybody pointing fingers at each other.
Thank you. Well, let's take this conversation towards the future now. What our discussion so far has given me is that there's an interesting insight here. Compared to the traditional one-to-one contracting model, there's really no incentive for a principal to do that anymore with the introduction of proportionate liability in a formal and an informal dispute resolution mechanism. So it really leaves you exposed as a principal. But there's really not much incentive. Let's say if you are a wind farm developer, while you used to do a full wrap EPC contract with the OEM leading the whole thing, but now there's really no incentive, in my view, to go with that approach, because at any point, if you do get into dispute, there's every possibility that it's going to turn into a multi-party dispute, whether you like it or not. So why don't you just protect yourself with a multi-contract form anyway? Look, I don't have that much visibility in the industry of how is the contract model trending in that type of context, but renewable industry would be quite interested to understand. Also from an offshore wind perspective, right? They're going to go into the billions, and in terms of packages, in terms of skills, in terms of equipment. So what do you think about that from an inside perspective? And to close off our podcast episode here, how would you wrap all of this up?
On the first question, I think the reality is that a full wrap EPC contract is becoming less common, and multi-package contracting is becoming more the norm. I think that's probably more to do with the financing and risk transfers than disputes, but I think it does sort of dovetail, I suppose, with what we've been talking about, of that the idea of just having a single point of responsibility when it comes to resolving a dispute is becoming less likely. Although having a single point of liability still has advantages. It's just that you may not be able to avoid the downstream dispute getting wrapped up into your upstream dispute. And we see things like linked claims regime becoming much more common in complex infrastructure. So to wrap things up, everything is becoming more complex. Contracts are becoming more complex. Projects are becoming more complex. God knows what AI is going to do to complexity of these things. Maybe it'll help us and simplify things, but I suspect it won't. And equally, dispute resolution is becoming more complex. However, I think there is an increasing recognition amongst the industry and dispute resolution practitioners of the value of, for projects and the participants, of working, it's hard to say working together because that's not what lawyers do, but recognizing that there is benefit in designing something that is directed toward finding a solution. And the long experience of projects that have ended up in very difficult, extensive, costly, lengthy litigation, I think, has frightened a lot of people, perhaps not dispute lawyers who might welcome that, but the industry doesn't want generally to be involved in that sort of thing, whether one regards that as a successful outcome or not. If you ask most people involved in a project, they don't want their project to end up in litigation for 5-6 years or even longer. So there is a recognition that we need to do something that deals with stressed projects, allows projects to continue, and brings a multidisciplinary approach to dispute resolution as we have multidisciplinary approaches to project delivery. So I think that's exciting. I think that bodes well for controlling disputes and for maintaining disputes and we talked about before that complex projects lead to complex disputes. I mean, that's almost inevitable. And so as practitioners, we need to come up with new solutions to help our clients and help the industry to deal with that. And I think that's an exciting time to be involved and designing those sorts of outcomes.
Excellent. Thank you, Dado. I would like to say, is the EPC contract dead? Or more ask, is the EPC contracting model dead? But I don't know. I mean, that's for the industry to say and decide. But from a dispute perspective...
Well, things change. Things change. Who knows?
Yeah.
Complex projects, I think, are not seeing a lot of that. But you never want to put a guarantee on what the future holds.
All right. We'll leave it there. Thanks, Dado. Thank you so much for joining us on the show.
Oh, no, thank you. It's been a pleasure to be here.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawana Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.